Welcome to today's webinar. For those of you who may be new to our events, the National Committee of North Korea, or NCNK, is an American organization which is dedicated to principled engagement between the United States and North Korea. Earlier this year, we had the privilege of working with the Center for Constitutional Democracy, Indiana University School of Law, Professor David Williams and his colleagues, on a project to compare the constitutions of North Korea and South Korea. There's really very little out there on this particular topic. And so we were pleased that in working with Professor Williams, in working with James Min of LimNexus LLP, collectively we were able to bring together a group of 13 scholars from 7 countries to consider the commonalities, the dis-commonalities between these two constitutions. Now, you may refer to our report, which is online, to review the names of all of the participants. We're pleased today that a few of those folks are with us as a part of this program. And I will turn to Professor David Williams to make some introductions of co-panelists. But first, in regard to Professor Williams, I want to take a moment to highlight his background. He is professor of law and the executive director of the Center for Constitutional Democracy at the IU Maurer Law School, where he teaches constitutional law and Native American law. He's a noted constitutional law scholar. Professor Williams has written widely on constitutional design, Native American law, the constitutional treatment of difference, and the relationship between constitutionalism and political violence. He's the author of a number of publications, and he's also co-editor and primary author of Designing Federalism in Burma, which is widely read in the Burma democracy movement, which, by the way, continues to be quite active despite the indications otherwise. As executive director of the CCD, Williams consults with a number of reform movements abroad. He advises many elements of the Burma democracy movement on the constitutional future of that country. He is a consultant to the government of Liberia on its constitutional revision process, and he has helped to write Liberia's law reform and anti-corruption statutes. He's also the primary author of the first treatise on the meaning of the Liberian Constitution. More recently, Professor Williams has become a constitutional advisor to the Democratic Party of Vietnam to help the party find ways to work with the government for peaceful reform. Williams graduated magna cum laude from Harvard University, where he served on the board of editors for the Harvard Law Review. Professor Williams.
Thank you, Keith, very much. And thanks to NCNK for asking us to join in this project. It's been enormous fun and enormously interesting. And NCNK has just been a fabulous partner in this respect. Let me start by introducing our wonderful panel of contributors here this morning. I'm going to be much shorter in these introductions than Keith has been because they're, of course, available in the material and we want to get into the discussion. But Professor Yonghoon Kim is a distinguished law professor in South Korea. So this subject matter is of more than academic interest to him. Justine Guichard is a distinguished political science professor at the University of Paris. And she is a Korean specialist. So this area is of central academic interest to her. I might also add, she's probably the best non-lawyer lawyer I know, by which I mean, she's as good a legal analyst as I have seen for somebody without a JD. And I don't mean that to be damning with faint praise. David Kenny is one of Ireland's leading lights when it comes to Irish constitutional law and comparative constitutional law. He shares with me the advantage of being new to Korea. So I'm hoping that that will allow us to bring a pair of fresh eyes and comparative perspective. Now, let me urge all of the viewers, if you have not read the report, please do read the report. It will help to understand what we're about to talk about. When we started this project, we were assuming that some of the conference participants would disagree with parts of the report. So they would be allowed to file a dissenting opinion. But as it turns out, there were no dissents. Everybody agreed. This was a unanimous opinion. And that leaves me in the unfortunate position this morning of having no controversy to foment, because there's lots of agreement already. So there will not be the kind of vituperative disagreement you look for in an event of this kind. So I'm going to start instead by asking our participants this morning to summarize parts of the report. And we had 4 clusters. Justine, may I ask you to start by summarizing the first cluster?
Yes, thank you. It's both a pleasure and an honor to be here. So the first cluster we dealt with was legality, constitutional interpretation, and constitutional enforcement. So basically, we interrogated the role of law in the North Korean and the South Korean constitutions, and we found out that law does play a role in both constitutions. In other words, we found that there exists not only a legal system, but also a conception of legality in both countries. Although, of course, this conception is not the same. So we agreed that the primary role of the DPRK constitution or North Korean constitution is to enable state power. That is to say, to organize and legitimize state power. Whereas the primary role of the South Korean or RK constitution is, of course, to organize state power as well, but also to limit it. In other words, the text empowers the state, like all constitutions do, and it also empowers citizens by providing them meaningful means of protection and redress. And so this led us to the conclusion that rule by law is what prevails in the DPRK, where the law is an instrument by which the government rules, whereas rule of law is what prevails in the RK, where, at least in theory, the law itself is the ultimate ruler and constrain what the government can do. So importantly, we also found that these different conceptions of legality appear to derive from different visions of the relationship between the state and society. So we're going to say, I think, a little more about that later. But basically, the state and society are seen as separate entities with divergent interests in the South Korean constitution, whereas are basically seen as part of an organic whole with shared interests in the North Korean constitution. And finally, we found that these different visions of the state and society relationship translated into different visions of constitutional interpretation and enforcement. So there are mechanisms for constitutional interpretation in both countries, but again, they are not the same. And to put it in a nutshell, there is in South Korea an independent constitutional court to which citizens can appeal to limit state power, whereas in North Korea, there is no apolitical interpreter. So I will stop here.
Thank you so much. Professor Yonghoon Kim, maybe you would summarize the second cluster for us.
Yeah, thank you for inviting me to this honorable meeting. So I was assigned to summarize the second cluster, the people and the assembly. So first of all, about the people, I think that there is the constitution of DPRK, RK, the mention about the sovereignty and the people, but somewhat different. I think that there is to some extent so many differences in there. So actually, RK constitution deals with the citizens' democracy, whereas the DPRK deals with democratic centralism. I think that we concluded that, but there is the crucial difference between them. So the RK, the constitution, choosing their elected representatives and mobilizing their rights to check the government. In other words, the DPRK constitution, the exercise their sovereignty through the organization of the state for the good of the public. So the DPRK constitution focusing on the power of the state organizations. And in this sense, the difference between both constitutions, the constitution framing, the RK, the constitution directly adopts the governing document by the wording, we the people of the Korea. And in other words, DPRK, as you know, the Kim Il-sung and Kim Jong-un and Kim 정의, the 주체, the ideology, the put on emphasis emphasized by the in that constitution. And elections allocate a number of candidates representing a number of parties. The DPRK, but DPRK only one name on the ballot, and the restrict public deliberation, discussion, and the unanimous will. So we could, and we concluded that in the Korean constitutions, there is the popular democracy. In other words, that there is the focusing on the power of the people. But where is the DPRK constitution focusing on the democratic centralism, focusing on the system or the political parties, the power, just like that. And the second issue is the legislature, the assembly. There is actually, as you know, the importance of the legislature is so crucial in the democracy or the states. But the socialist constitution, for example, DPRK constitution, formal sense, in a formal sense, they have the institution, the assembly has the most important institution for popular power, and the representatives is there is, and indeed they have the fairly unlimited power. But in the report, the panel also noted that the DPR constitution, the legislature's role might be considered to reflect something like Rousseau's concept of the general will. So actually, the Professor David gave me assignment. What does that mean? But the panel is me. So I think that I sent somewhat the summarization of these ideas and to the David Professor. But I think that I'm afraid to deal with this issue because we have the time limit. So
I think that's a good idea. Yes.
Yeah. So I think that I should the summarize the condense the idea. So actually, Rousseau put an emphasis on the specific individual, the sovereignty. So he put an emphasis the idea that there is no need. We don't need the representative because he just deal with the direct democracy, but we cannot assemble at the same time and in the sense and in the time, and the people is considered to be the ignorant, not smart. So Rousseau admit that we should have the representatives, but representative should not have the free will. Just they decided according to the general will by the moderated by and made by invented by the Rousseau. So actually Rousseau think that the representative is just like the robot, just AI. Make a decision according to the will of the people. But in the sense, but anyway, the assembly, composed of the representative is the most powerful because they are representative of the people, and there is no institution can regulate or the check and balances against the assembly. So in the sense, the Soviet or the socialist constitution took an advantage of that idea of the Rousseau. They have the assembly, and the assembly has the representative of the people, and the people entrusted their power to that assembly. The assembly is the most important and the most powerful, though they cannot. The institution cannot regulate. So I think that the Rousseau did not intend to that intend and wanted to his idea is took an advantage by the socialist constitution. But anyway, I think in the Korean or some the scholars interpret and analyze the Rousseau's ideas just like that. But so I think that I should admit, I should confess that my argument and my comment can maybe the wrong. That is not the truth. That just one of the analysis, one of the interpretation of that the Rousseau's ideas is like that. So
thank you very much. One of those rules that all academics learn when they're very young is that it's absolutely impossible to summarize Rousseau. All you can really do is just reproduce the language and hope you kind of glean it from the original context. David.
So I can conclude my comment. So, but where is the difficult constitution, RK constitution? According to RK constitution, the Korean Assembly has the power. I think that based on the rule of law, based on the constitution, to impeach, inspect the competent ministers to attend the parliament and to conduct the personal hearings for executive appointments, just like that. Yeah, thank you.
Great, thank you so much. And David, how about the last two clusters?
Thank you so much, David, and to Keith and the NCNK for having me. It's been a delight to be involved with this project. Our third cluster that we discussed as a panel was the structure of the executive in each place. And it's a common feature of constitutional systems worldwide that executives often have more power in practice and de facto than the text of the constitution would suggest. And we found the same to be true in the DPRK and the ROK, however, with significant differences perhaps in how that played out in each place. In the ROK, while the directly elected president is extremely powerful and clearly dominant say in the relationship between the president and prime minister, it is clear the constitution is concerned with limiting and curbing the power of the president. The constitution does contain a deliberate attempt to depart from any notion of an imperial presidency that may have been common in the past, but should now be seen as a threat to be curbed. And indeed, though there are many elements of presidentialism in the ROK constitution, such as decree and veto powers for the president, there are other aspects of the system of government that resembles the panel more like a parliamentary system in the parliamentary tradition. As the report describes it, it is perhaps presidentialism dressed up as semi-presidentialism, and the line between those two is difficult in cases to chart. In the DPRK, however, the extensive power of the Supreme Leader, or the Chair of the State Affairs Commission, as he is also referred to, is clearly a design feature of the system of government. And the Supreme Leader does not share power with anyone. The Supreme Leader, as a matter of state ideology, is clearly to be the center of the state. And the constitutional system in practice is seen to reflect and uphold this. The Supreme Leader essentially is seen always to buttress and defend, rather than in any sense threaten, the constitutional order. And though nominally accountable under the Constitution to the Supreme People's Assembly, there is no process for this accountability of the Supreme Leader provided for in the Constitution, and it is understood that removal of the Supreme Leader is not possible. The Supreme Leader is also not elected per se, but his status is rather declared and affirmed by the Supreme People's Assembly upon its election. The panel essentially concluded that each system has a very different theory and vision of the executive power. In the ROK, the imperial presidency is possible as a powerful president takes on more and more responsibility in order to produce results. But the constitution sees this as a threat to be countered. The DPRK, on the other hand, sees that people have a duty of fidelity and loyalty to the regime, which has their best interests in mind and will protect them. And the state is thus something that protects the people, not something that is a threat to them. And the Constitution seems to recognize that understood reality. The fourth cluster that we dealt with was political parties, and the panel concluded that, perhaps surprisingly, the same set of underlying ideas motivated two quite different approaches to political parties in the two constitutions. In the ROK, political parties can help the people control government, whereas in the DPRK, the party seems to help the government control the people. The ROK constitution provides for a multi-party system and protects rights to form political parties and otherwise associate in order to influence governance. Though the DPRK nominally allows for other parties to exist, it is in practice only the Workers' Party of Korea, WPK, that has any power. Other parties are adjuncts or offshoots of that party, and that party's centrality to the state is acknowledged on a couple of occasions in the text of the Constitution. However, from the outside, the panel found it difficult to understand the precise nature of the WPK's influence. It appears to be substantial during the tenure of Kim Jong-un, but again, it's difficult to know precisely what that is. It was unclear if the party does play some small checking role on the leader and the state, but in any event, the party seemed to serve to educate citizens, provide a venue for citizens to have an associational common life, and may allow certain individuals or factions to compete for greater primacy in North Korean society. It was also clear that both constitutions tried to protect against problematic political parties, but in quite different ways. The ROK constitution has a process for the Constitutional Court ultimately ruling on the idea that a political party is a threat to the democratic order, whereas the DPRK constitution contains a much broader constitutional authority, where it's envisaged that the state will combat anything that is a threat to the socialist system or that would subvert it, which would include, of course, subversive political parties. These two clusters, like the two discussed by my colleagues, showed fascinating convergence and divergence between the two constitutional orders. They showed the two systems addressing similar questions, but in profoundly different ways, and showed how the text of constitutions is really always only a starting point, never the end point of understanding how a constitutional system works.
David, thank you so much. And thank you to the other two participants as well for providing us that abbreviated summary. Again, I refer the viewers to the report for kind of more information. But Justine, this morning, let's start with you. You've written broadly on Korean constitutionalism and you speak Korean. You're embedded in this whole way of doing things. Is there anything from the conference that struck you particularly? Anything from the report and the findings and from the views of the other participants that you think the viewership here should take away?
Yes, there are actually a number of things that did strike me. What was very helpful, I think, for me was I was a bit familiar with the text of the constitutions, but the panel provided me a new language to think about aspects that I had researched before. And for example, I was very struck. So I previously worked on South Korean constitutional jurisprudence, and in particular on how the Constitutional Court of South Korea defines a boundary between what is national and what is anti-national. So I would say that my vision of South Korean constitutional law and my vision of South Korean constitutional case law is not one that only protects individual rights, far from it. And in the Constitution of South Korea, I tend to read more, I tend to give more attention to clauses, for example, that do affirm state power over citizens' rights. So what I thought until basically we had the panel, we had the conversation, what I tended to think of as repressive clauses or repressive provisions in the South Korean constitution. Like, for example, Article 37, where is stipulated that basically fundamental rights can be restricted, like the provision on the dissolution of political parties, etc., etc. So what I would tend to see, again, as repressive clauses, places where the state affirms itself, affirms its power against citizens. And with the panel, what struck me is that legal scholars, constitutional scholars, comparative legal scholars at the panel precisely saw those provisions as hallmarks of the rule of law.
Yeah.
And for me, that was very interesting. That the fact that there is a limitation clause on fundamental rights means that the Constitution takes fundamental rights seriously. And then David Kenny raised the same for emergency power. And then that led me to think even of the provision on the dissolution of political parties along that line. So yes, it helped me basically shift a bit my understanding about those things I was familiar with, but that I wasn't reading in that light.
It's terribly interesting. And of course, legal scholars will be thinking of this from a judge's perspective. And so limitations clauses or detailed provisions put limitations on what a judge can do. So David, Justine just referred to you, so let's go to you for a minute. She suggests that in certain cases, in the case of South Korea, limits on rights can actually be protections for rights. Do you see this in Ireland and the rest of the world?
Yeah, absolutely. One of the things I've been really interested in my scholarship is the idea of limiting rights. And I think, again, almost counterintuitively, the more detailed you are in the way you go about limiting rights, the more likely you are to take those rights seriously. Otherwise, rights become worryingly sort of can become worryingly meaningless value commitments that don't take on practical effect. They may animate a political culture or they may not. However, if you articulate how rights are limited, you're in fact articulating what the right really means and how to take it seriously in practice. And it's something that I think is very interesting when you're looking at constitutions around the world, is that the countries that seem to not protect rights in absolutely broad brush ways are often actually signaling a commitment to taking those rights very seriously. And as Justine also said in respect of emergency powers, there was an interesting, again, comparison there that the ROK's much more specific provisions about how emergency powers were to be used was a signal that emergency powers were something that you have to be sort of potentially concerned about, that have to be used, but only in a time of exigency. Whereas we would see emergency powers provisions in the DPRK, but with very few limitations on that, perhaps suggesting that in fact, those emergency powers may not really be necessary. It's not really envisaged that they would have to be used because the constitutional system will be quite facilitating of broad executive action. And it's the articulation of limits that might give us the sense that the ROK is really constraining the executive and only in certain circumstances letting it loose, setting it off that leash. And again, I think that's one of the values in these comparative projects, is putting these side by side, allow us to know by contrast and contradistinction what these things will really mean in practice.
Thank you so much. Yes, so all that's going to work, of course, if but only if the language in the Constitution is binding and there is somebody who will take it very seriously as a law. And so we'll go through it with a kind of careful perspicacity that good courts might bring to bear. And so that has a vision of law as, relatively technical, relatively detailed, relatively specific, but also quite powerful, and therefore restricting powerful people. Now, Professor Yonghoon Kim, let me ask you to jump in here. And of course, I'm asking you to speak about this from a Korean perspective, from a South Korean perspective. The panel, I think, at the conference reached the conclusion that there was a huge difference between the two Koreas in this respect, that the notion of law was at work in the North, but not this sort of technical lawyers type law, really a rather different vision of it being vouchsafed, being committed to the good discretion of leaders. Would you say something about that, please?
Well, I think that there is the objective meaning of the law and the concept in the world, the legal system. But actually, the Constitution that has to be made based on the will of the people. So the Constitution is that the legal norm based on the will of people, because in the process of the making or the revision, the amendment, people should attend, and the people should participate in the constitution making or the revision. And the law is made by the representatives, the lawmakers, the selected by the people. I think that there is somewhat objective meaning of the legal system, the legal norm in the world. I think so, but I think that there's a slight, or in some sense, to some extent, there is the broad difference between the meaning of the law and the legal system, the legal norm between the Korean legal system and the North Korean system. Because I think that there is because the reason why there is the difference between two systems, there's a focusing. The focusing is a different thing between the Korean, South Korean, and North Korea, different and the ROK. As you know, in the legal system of the ROK, they focusing on the people's power, because as you know, we have the democratization. There is the harsh and there was tough time. But as you know, the 5 to 18, the democratization, the movement, just like that. But I think so. We should adopt the constitution, and the constitution for the sake of the people's willpower and the people's opinion, just like that. But North Korea is focused on the just 주체 or the ideology for that Kim Il-sung, Kim Jong-un, Kim Jong-il, just like that. So I think in the sense, but I think that I cannot, but because after the finish of that, the late time of this conference, just like that. So I realized that I cannot blame, I cannot make light of the North Korean differential constitution, because there is the picture and there is characteristic of the differential constitution. But just like the one picture, the important picture is just like that, that they focus on the juche ideology. And in the sense, whole the legal system, the whole the legal meaning is to focus on that sense, on that aspect of the juche ideology. So I think that in this sense, I think, but as the said the David and David and Justine just like that, I think that there is the limitation. We focus on the limitation of the political power just like that, and the focus on put on emphasis on the people's power, people's opinion, where least North Korea just the focus on the opinion of the Kim Jong-un and the juche ideology just like that. So I think that there's a slight and the broader the difference between the Korean and the South Korean and the DPR case and the legal norm, the sense just like that. Yeah.
Thank you so much. So this is absolutely fascinating, and I'm struck by the fact that you just said you can't blame the North Korean Constitution, and you don't want to make light of them.
But actually, but actually but before I took part in the conference, the conference. Actually, I think that I have the prejudice, stereotype about the DPRK constitution and the legal system. But actually, the DPRK has the nickname. There is a frozen land, Iceland, just like that. But in the sense, most of the Koreans has the thing. There is the legal system and the constitution in the DPRK is not so good.
Yes, of course.
In the sense it's bad. In the sense, but while I take part in attending the conference, I think that the most of the panels and what the including the Professor David find the positive meaning and the good meaning and the good aspect in the DPRK constitution. I was struck by that attitude, just like that. So I think that we should have just like the attitude. We can continue. We can keep on the studying and the North Korea DPRK constitution. So I think I was struck by there can be the positive meaning, positive aspect in the North Korea DPRK constitution, and I was struck by the attitude of the panel of the David, the professor. Yeah.
Thank you. So it is certainly the case that the goal of the conference was to be as fair as possible to both the constitutions of the North and the South. No pre-commitment to finding something good in the Constitution of the North, but to be as fair as possible. And part of what we discovered early on was this, that you describe a constitution as the product of the people. And it's a vision of liberal legality, that the people write constitutions so as to limit their government and government officials. And right away, we came to realize that if that's the definition, then in all likelihood, the DPRK constitution is not actually a constitution at all, because that's not the point. And so we had to reconceptualize this to have a broader definition, simply to be able to compare these two things. Now, Justine, with that in mind, let me go back to you. You've written this very interesting work about conceptions of the people in the North and the South. And I wonder if you could unpack a little bit more of that, particularly, I hope, addressing the fact that when we speak of countries that have liberal legality, we talk very casually about the people writing the Constitution. But of course, we know that's not true anywhere in a literal sense. It's always an elite-driven process. So what's the real difference between the role of the people in the North and the South, if that's the case, in the two constitutional traditions?
Yes, thank you. Yes, so I did write on conceptions of peoplehood in both constitutions, comparing this time not the two current texts like we did, but looking at various iterations of both texts and the founding constitutions in particular, and as they've evolved since. And And I think this was an interesting exercise because the two founding constitutions from 1948 are in a sense much more similar than the current constitutions are, and did tend to see the people, or to speak of the people in similar terms, although the words used in Koreans are different, just to say the people. So there is this basic difference. And then I think that the current part of the current differentiation between the two constitutions that we see today can be traced back to 1972, when North Korea replaced its constitution and adopted a socialist constitution, which articulated a different understanding of peoplehood. Peoplehood more conceived in terms of class, the people being the working people. And what's interesting to me is that we discussed that during the panel, but in today's constitution in North Korea, we tend to see the people being discussed along those two different lines. In other words, we do find those two languages in the constitution, the people being talked about as an organic whole through the unanimous will of the people, and at the same time, this language of class conflict that tends to separate the real people, and the working people in particular, from the rest and from enemies. And in South Korea, I would say, and Yonghoon, you refer to very briefly to the Gwangju uprising. But what's interesting too is I believe the current constitution, the current democratic constitution, was also in a sense written against alternative conceptions of peoplehood that did exist during the democratic movement. So,
thank you. So the people of South Korea, though, have been unhappy from time to time, sensing that they really were not in control of their government. They were sidelined. And maybe that was true at the very beginning as well. Are the people here just a fiction that those countries that have liberal legality use to comfort themselves, to believe the people are really in charge?
In part, yes, I think in constitutional texts, that constitutional texts are interesting because they articulate claims about the people and who the people are, and that this vision is in part fictional, but that's an interesting fiction. That's a real fiction in a sense to study.
So then if we look at historical fact, is the difference between the two constitutions one of degree or one of kind in the role that the people play?
That's for me again.
Yes. I'm going to go to David in just a minute and ask about experience in other countries, but for you now, because of course Ireland, grapples with the idea of the Irish people as well. But please, yes, go ahead.
I would say in the current constitution, yes, it's a different kind of visions. Different kind of vision of peoplehood that's articulated, but that came about over time. That wasn't necessarily there in 1948 in the text of the Constitution.
Okay, I understand. Thank you. So David, now let me go to you. People in Ireland talk all the time about the Irish people, but we know, of course, that the Irish people, to some extent at least, are politically divided, and you're facing an interesting future in the next 5 to 10 years in the island. In Ireland, when we speak of the Irish people, are they actually a moving force in constitutional politics, or are they just a name to conjure with? And how does that cause us to reflect more on the situation on the Korean peninsula?
Yeah, I found reading these two constitutions to be fascinating on these questions, because both constitutions refer to sort of unification or reunification as a priority. And one of the things I found particularly interesting was some real similarities between the ROK Constitution and the original text of the Irish Constitution, in including essentially a broad territorial claim. The original Irish Constitution said that fundamentally the territory was the island of Ireland, but that for the time being, the laws would only apply in a certain portion, kind of ignoring that time being and how long it would last. And I saw that very sort of closely replicated in Articles 3 and 4 of the ROK Constitution, which talks about the territory of the Republic of Korea consisting of the Korean Peninsula and seeking unification peacefully based on principles of freedom and democracy following straight after. And similarly, Ireland has had to grapple. We had a sort of very famous peace agreement in 1998, often called the Belfast or Good Friday Agreement, under which those provisions of the Southern Irish Constitution changed and essentially limited the territorial claim and acknowledged that any sort of unification would only take place on the basis of consent north and south. And something that I think we still struggle with is the identity of the people of Ireland. That's something that in the south of Ireland, there's a very strong sense of identity. People vote in constitutional change referendums, a sense of polity in the electorate. But it's very unclear how that can accommodate, as the people of an all-island Ireland that ever come about, a group of people who do not identify as Irish, who very strongly identify as British, and reject any characterization as Irish in that sense. And I was fascinated listening to Justine's account and others during the discussions about the idea of the people and how the people sort of played out potentially as differently constructed entities or differently conceived entities in this context. And in particular, the DPRK's claim to for, let's say, the supreme leader to sort of be appointed by the will of all Korean people. And again, in Article 1, the idea that the DPRK acts for all Korean people. I found those claims to be really interesting, and obviously the tensions in that with the political reality and the divergence that exists in practice were something that I think I would have loved to discuss and study more. And I hope that I will be able to, notwithstanding the limitations of my language, limiting my access to primary source materials.
Great, thank you so much. So it's interesting in Ireland, of course, because early on there was a sense that the people of Ireland kind of constituted a whole. There's a sense now that although there's more generosity on both sides of the line, I think it's fair to say there's a divergence and maybe an increasing divergence. And Yonghoon Kim, let me go back to you on this subject. Do you think that with respect to the legal culture in particular, with the legal culture, the North and the South are growing further apart or coming closer together?
But actually, but we have the correlation, we have the contact and communication between the North Korea, South Korea in terms of a culture, the cultural the event, the long time ago. But actually, the country and our government try to import and disperse our legal system to the South Asia, such as Vietnam and Malaysia, just said. But I think that the informal sense, we do not contact and we do not communicate with the North Korea, DPRK, the reader or the politicians in terms of the legal the system or the legal the sense, just like that. But I think the substantially. But I'm not sure there is the correlations or the communicate or the interrelations between the DPRK and the South Korea, the culture. But I think that rather than that, there is the isolation and so I think in the sense we have the Koreans, DPRK, RK has Korean, but there's so many different languages and the expression and even though we have the same Koreans, in that sense we have the so different legal system and the legal sense between the system and the North Korea system. So I think that there is no apparently the conspicuous characteristic of that legal culture, the correlationship, just like that. Yeah, but I'm afraid to say like this, but I cannot catch the gist of your question. What does that mean? So what the correlate the
No,
legal
thank you. Right,
yeah,
I think you've answered it. That law ideally is going to be a representative of the local culture. It's not like science, which maybe can be global. It's got to be actually embedded, and therefore it's also going to depend on the language and the way it's used. And we know at this point that North Korean legal language is substantially different from that in the South. But I asked the question in part because I know NCNK is dedicated to the hope of engaging people in North Korea. And part of the point in this project was, in fact, to promote interaction between legal professionals in North Korea and in the rest of the world. And with that in mind, I think it's probably now time
yeah. So,
questions.
but I think that there is yes. I think that it's just said to you that there is the isolation and the difference between the different legal system and our legal system, just like this. For example, even though the certificate of the doctor or the PhD in the North Korea that came into our country, the domain of our country, we cannot admit. But I think that there is exceptional case. But in principle, we do not admit the certificate or the just like that doctor or the PhD, the lawyer, just like that. So I think we should, when we reunited the later, but I'm not sure when the time is to come. But when we united the later on, so we should try to unite the legal system between the North Korea and the South Korea, just like that. Yeah.
I understand. And do you think that reunification of the legal system will be more difficult in 20 years or less difficult in 20 years?
I think the more difficult.
More difficult.
Yeah. I think that's like that. Yeah.
Thank you. So with that, I think we should probably bring in some of the viewers, and I turn this over to Keith Luce to handle the questions and comments.
Professor, thank you. And just some additional perspective on the immediate topic related to Professor Kim's responses to some of your questions. I should note that North Korea was invited to send a scholar or two to attend the workshop. North Korea did not respond to that invitation. After North Koreans have an opportunity to view today's webinar and or read the report, if at that point the North Koreans decide they'd like to make a comment, we are certainly open to receiving those comments and making those public. I also should note that in terms of the workshop in this project, it is the hope of NCNK that over the long term, this project will help contribute to more interaction between the North Korean legal community and that of the United States and other countries. It will come as a surprise to some of our audience that Americans have been involved in the past in providing legal training to North Koreans in a variety of fora. But now let me turn to some questions that are coming in. And David, I will direct this to you and you can decide if you will respond or one of the other panelists. John Delury from Seoul writes, and John says, I'd be curious if panelists compared and contrasted the DPRK Constitution and the history of revisions to it with the constitutional orders of its sister states, Communist China and Vietnam. Take, for example, the evolution of executive power in the three socialist countries. Are there parallels in constitutional changes under Kim Jong-un and Xi Jinping? David?
So the short answer is the conference did not address that question. My recollection is that we did talk about Vietnam a little bit because the parallels were so close, but this was not a major focus. It certainly, I think, would be a terrific focus for future work. But Justine, I know, has done a lot of work on socialist constitutions. So let me direct the question to her. Are there similarities and parallels between the two, Justine?
No, unfortunately, I'm not able to answer, not knowing the Chinese case enough. But it's what I saw also after the panels, that not on comparison is important, and it should be a project to compare not only the North Korean constitutions with Chinese, Vietnamese constitution, but, and David was mentioning it, the South Korean constitution with that of previously or currently divided countries like Germany, Taiwan, Ireland. That'd be fascinating. But there have been a lot of revisions under Kim Jong-un, and a lot of recent revision of the North Korean constitution, but I'm not able to draw a comparison.
Great, thank you.
So could I briefly comment, David, if I just very quickly, and I would confess my limited knowledge of the Chinese legal order as well, though I'm fascinated by it. It's so complicated, and again, accessibility of materials without language skills I find so difficult. But it did strike me as there was potentially really interesting comparisons, because it struck me that in many ways the Chinese legal system and some of its concepts, like again, excuse my pronunciation, but fatsi, the idea of a particular Chinese interpretation of the rule of law that is subject to the leadership of the party, or socialist rule of law with Chinese characteristics. These concepts struck me as being somewhat similar to the way that we describe this North Korean rule of law, perhaps with a slightly different cost-benefit analysis. Some of the analysis I've seen of the rule of law in China has suggested that China does a cost-benefit analysis on complying with international visions of the rule of law on a case-by-case basis. The calculations change as time goes on and China's position changes. And it struck me that perhaps you could view the North Korean calculation in somewhat the same way, that there was less incentive perhaps than there has been in China at certain times in the past to appear to comply with certain more internationalized aspects of the rule of law. So the same approach might underlie them, with different results based on their differing circumstances. But I would confess, not enough knowledge of either system to draw that in anything other than the most tentative way.
Yeah, thank you so much, David. So, right, one thing that the conference did talk about is the fact that clearly there's a socialist element to the North Korean constitution, and the degree of strength and the degree to which it ebbs and flows. We spoke a little bit about it, but it's very clear at the same time that the government of North Korea is not trying to be an orthodox socialist state, that there are lots of indigenous elements that enter into it, and they're very, very self-conscious about this. And part of what's fascinating about studying this particular constitution is the combination of the outside elements and the inside elements. I think it's also just worth commenting before we go to the next question that if it is the case that the North Korean legal community comes into closer contact with people in the outside world, it will be very interesting to see how that happens, how that plays out, in part because, of course, the tendency over the last 50 years is for law around the globe to become more alike, just because it facilitates interaction. And to a very meaningful extent, North Korea, of course, has been an exception to that rule. It'll be fascinating to see what happens in the next 10 and 20 years. Keith, perhaps another question?
All right, thank you, David. James Min poses the following: what would you say to critics of the DPRK who view that it is an autocratic system where law does not play a significant role?
Very good. All right. So, and I should mention, this comes from James Min, who was a very salient participant in the conference and a great support. And so I'm really glad to be getting a question from him. Yonghoon Kim, perhaps you would take a crack at that question. What would you say to critics of the DPRK who suggest that really, in fact, that constitution is, in a sense, just a sham constitution?
Well, I think that constitution should be the living constitution, because the constitution react the social demand and the people's demand and the people's opinions. So in the sense in North Korea, the DPRK constitution, just as I said to you, just focusing on the Juche and the Kim Jong-un's Kim Il-sung ideology, I think that they revise the constitution more than our constitution. Our constitution is revised the 9 times, but I think that the much more the revision is there in the North Korea's constitution, but they are criticized that the revision is just for the sake of the reinforcement of the political party and the Kim Jong-un's power, and there is the regardless of the people's right and the people's the welfare, just like that. So I think that, as I say to you, I respect, and I should not make a leader of the concept or the importance of the North Korean constitution. But in the sense, the North Korean constitution is the much less, and just like that, somewhat the deficient of the modern concept of the constitution in this world, and the comparison with our constitution or the other constitutions such as the United States or the Japanese, or just like that.
Thank you very much. Yes. So, Justine or David, do you have anything to add? Of course, as I mentioned earlier, our goal here was to be fair and in a certain sense to take seriously the North Korean Constitution, but not to cover anything up. And so it was just a mistake to actually take this intellectual structure that seriously? And should we just begin with the assumption that there's no such thing as law in North Korea?
No, I think that what our discussion reveals is that law matters, but it matters in North Korea because it's an instrument to organize and to legitimize power. So in that sense, it's not a sham, I would say. It's really a window. Although I saw some questions that are coming up. Of course, it's not a transparent window into how the state and how society works. In that sense, it's a limited window, but it's nonetheless a window onto how the state conceives of itself, how it sees its polity, the claims it makes about itself, and that in itself is significant and should be taken seriously. Mm-hmm. And on top of that, there is this evolution. So if you just look more precisely at the structure of the executive and the recent revisions we were talking about, those are reflective, those shifts in power, changes in power related to the different hereditary successions, those do come across the constitution and successive revisions with different organs being in charge of executive power under Kim Il-sung, under Kim Jong-il, under Kim Jong-un. So this is also interesting.
Thank you. So what people choose to tell you about themselves really matters, even if it's not an exact description of facts on the ground, because it gives you an insight into the mentality. And hopefully when it's a constitution, the stuff that they're telling you is pretty fundamental about their own self-perception, or at least the perception that they would like to advertise abroad. And so it's a starting point, perhaps, for engagement. David, would you like to add anything before we go to the next one?
Just briefly, because I think I very much agree with the other comments that have been made. But I think that particularly when you're working in sort of comparative law or comparative politics, it's important to remember that to take something seriously in order to understand it is not to endorse it or to like it. That, as Justine said, to understand something written in a constitutional law is not to understand the practice or the experience of that law on the ground. But I think something that a former professor of mine said to me, which always stuck with me, that a constitution can often be consistent on its premises, but you don't like the premise, right? And so if you put aside not liking the premise, to understand it by taking its premises seriously, I think is a useful intellectual exercise. And in particular for really a good way of understanding the context and the legal structures that surround a polity and a community. And I found that the exercise of looking at the premises of the DPRK constitution in terms of Juche and in terms of the centrality of state ideology, really interesting and quite unusual from a comparative point of view. But again, that is of course not to take too far what that exercise actually results in.
Great. So those sound like very profound words to me. And with that, Keith, maybe we'll go to another question.
Brad Babson asks, how do the two constitutions differ regarding territorial application?
Oh, okay. And I think that's changed over time. Justine, let's start with you on this one, and then we'll go to Yonghoon Kim.
Yeah, actually, yeah.
Please start.
Either way, either one is fine.
Yes, go ahead, please.
Yeah, so I think that we talked about the people, the concept of people, and the application of the constitution between of the North Korea and the South Korea. But actually, I think the North Korea and the DPRK constitution do not the domain or the scope of the application of the constitution, but we have just like the our constitution, the Article 3, the saying just like this: the territory of the Republic of Korea shall consist of the Korean peninsula and its adjacent island. That means that concludes the North Korea the territory. So in the sense, the Supreme Court and Constitutional Court declare that the territories concludes and includes that the North Korea. In the sense, the North Korea government is anti-government organization, and in the sense, the people in the North Korea territory, the people, the South Korea's people, in the sense that the North Korea the people came into the domain, our scope of the territory in the South Korea. They do not need to take the measure just for the having the nationality of our South Korea. They, in the sense, they are in themselves is the South Korea's people. So I think that, but I think that the provision of the constitution is the criticized because the provision is not efficient, or that is not the real, because that the constitutional provision is meaningless in terms of that North Korea is the real and they are the member of the United Nations, just like that. So, but I think in the sense, in principle, our constitution declares that our application and the effect of our constitution is the reach to that North Korea's territory based on the constitution, the provisions.
Thank you very much. Justine, would you like to follow up on that?
Yes, maybe just to add that, so indeed, one of the striking features of the South Korean constitution is that it maintains this fiction of territorial unity. In Article 3, also institutionally, for example, in the design of the National Assembly, there was never any mechanism to represent North Korea. The way, as I understand it, it was in Taiwan when there was sort of fake delegates. So that never existed in South Korea. In North Korea, the claim to fiction to territorial unity existed too in 1948. In 1948, the constitution stipulated that the capital of the DPRK was Seoul. And that was withdrawn in 1972. It's one of the big changes. And now the capital is recognized as being Pyongyang. And on top of that, in Article 9 of the current DPRK constitution, there is this claim that the DPRK strives to achieve the victory of socialism in the northern half of the peninsula. And so yes.
Is it fair to say at this point that both constitutions are pledged to reunification, but at the same time, each country recognizes the right of the other to exist? And so if there's to be reunification at this point, it's going to be peaceful and negotiated.
That's an ambiguity, I would say, of the South Korean constitution, which is at the same time committed to reunification as a horizon, but still claims that its territory is all of South Korea, whereas North Korea constitution is more territorially based. But those claims to, those commitments to reunification, they were only inserted in 1972 at a moment when both Korean constitutions were revised or changed and actually affirmed more than before their specificities, their singularity. So socialism in the north, and for the south, the defense of what is called the free democracy, which in 1972 meant anti-communism. It had nothing to do with liberal democracy.
I understand. Thank you. So David, does the experience of Ireland here have anything to bear on this question? I mean, I'm just struck by the parallels throughout.
Yeah, no, I think it is potentially interesting, and I think that just to follow up on something Justine said, that when we amended the Irish Constitution in the South in 1998 to take out the territorial claim and to make it clear that unification would only happen with sort of consent on both sides of the border, that was in a way a recognition of how far things had moved along since the writing of that original constitution in 1937, which saw unification as something perhaps not over a distant horizon, but potentially somewhat imminent, and certainly didn't think perhaps that consent principle would be at the core of things. And what's interesting is that compromise that we made in 1998 on that basis set up this sort of self-governance in Northern Ireland within the United Kingdom, recognized the reality of Northern Ireland within the United Kingdom, but gave a constitutional path forward that unification could take place under these specific conditions with referendums on both sides of the border. But something that we've been dealing with recently, because after Brexit, talk of unification has increased. I still think it's a ways off, but it's being talked about in a way that it wasn't before, has revealed that actually the constitutional specificity of that deal is not great, that we have a lot of unanswered questions about what that process of unification would look like. So I think perhaps with anything like this, it's a process of stages and growing closer, and putting in place a scaffold that can be used to build something more afterwards, rather than perhaps, as we saw in the German case, of essentially unifying on a dime. That might be something that you can really only do in a pretty exigent circumstance, such as Germany experienced at its moment of unification, and that maybe other processes, if they're going to happen, are going to be more gradual and present challenges at each stage to address.
Right, thank you. That's so, and putting aside the question of Korean reunification, it is of course a really interesting question whether it's possible to generate that kind of legal scaffolding, whether through domestic statutes or international law, to govern the relationship between the two Koreas, to kind of promote a more peaceful interaction. Now, those would obviously not be constitutions as such, but they, over time, they might develop something of the importance of constitutions. We've certainly seen that elsewhere in the world. Keith.
All right, David, thank you. We have, I think, 3 remaining questions before we conclude. First, Michael Marshall poses, are there ways in which North Korea political practice significantly departs from its own constitution? Now, from my perspective, the answer would be according to where someone sits, right? If you're part of the leadership in Pyongyang, or perhaps the people of North Korea, or external observers, I think the answer would be it depends upon how one actually defines this. David, how would you answer it?
I would actually turn to either Justine or Yonghoon to answer that question. That's how I would answer it.
Yeah, but I think that it depends on the perspective, who see that the practice or the constitution. In the sense, in the inner circle of that North Korea, the political party or the politician in the North Korea, and in the people in the North Korea see that the practice, whether the political practice is conforms to the constitution provision. I think that they say yes, but other side, outside, the people outside of the North Korea see that the practice, whether the practice conforms to the constitutional provision. I think that there is possibility they can say that no, because I think that there is the people who see that the practice is the different, its estimation of the practice that departs from its constitution, just like that.
Yeah. And the one thing I would add to this is partially a question about empirical facts on the ground, but it's also partially a question about constitutional interpretation, because there are phrases used in the constitution of the DPRK that I think I know what they mean, but I have to keep catching myself, because it's a completely different interpretive community. And so, for example, the DPRK Constitution provides that the supreme leader shall be chosen by the unanimous agreement of the people of North Korea. Now, coming from an American perspective or a South Korean perspective, you expect at that point that there's going to be some kind of process to poll the people and find out what their unanimous view is, and then somehow cajole them into being unanimous. But of course, in the context of interpretation in the North, that's not actually what it means at all. And unanimous agreement here means something completely different. It's something I don't profess to understand. And it feels very metaphysical to me, not at all like the kind of law that I'm used to dealing with, but that's the whole point. It's another kind of interpretive community. And of course, we all know what it really means is that the succession to the supreme leader's position will be hereditary within the Kim family. And somehow that's the same as the unanimous agreement of the Korean people. Now, obviously, this is a different world, and we have to make a jump here to be thinking epistemologically in a very, very different way. And I'm also struck by the fact that during the conference, a number of the participants commented on the fact that a lot of the legal thinking in the North had the quality of religious thinking, especially with respect to the Kim family. And I once went to divinity school and had another life thinking in religious terms along those lines. And this is a conundrum, of course, that we deal with constantly in theological analysis. Religious language typically is not and cannot be denotative in any simple sense. It's a reference to something else that can't be understood in quite those ways. Now, that, of course, is a challenge for us outside of the North to try to figure out how all of this works internally. It may, of course, be total hypocrisy, or it may be, as David and Justine earlier were suggesting, that there is an internal consistency here, even if in the end we choose to reject the premises, the normative premises on which it's based.
But I think that in order to keep the right of the question, are there ways to just blah blah? There should be the concept or the argument that there is the practical practice differs from its own constitution in North Korea. But I think as I studied from now until now, they tried to keep and observe the constitution, because in the sense, in order to keep and in order to observe the constitution, they make the law. And I think that there is so many, a great deal of the laws. There is the decree and the law, and there is the local government decree, just like that. So I think as I said to you, we should find out whether there is the NK political practice that departs from the constitutional provision. But I think that I'm not sure there is the political practice that they try to deviate from the constitutional provision. But there might be. I think that there might be the political practice, but I think that they in formal sense, even the informal say, they try to keep and comply with the constitutional provision. But yeah, I think so. Yeah.
Okay, thank you. Justine or David, would you like to jump in here before we go to the next question?
Yes, maybe one area where there seems to be a great divergence between constitutional textuality and political practice is that of fundamental rights, because the PRK constitution enumerates a number of rights, etc. What I find interesting, and this comes back to what you, David, and Yonghoon were saying, it's that actually the PRK constitution articulates at the same time its own vision of rights, which is not at all a liberal one. So even in that sense, you may have the impression that the North Korean constitution lies enumerating rights, but it is also very explicit in articulating a vision of rights where it's basically one for all and all for one, a very collectivist vision. So in that sense, this different vision can be for rights, I find is very explicitly laid in the Constitution. For other area, it's not as explicit. For example, accountability. There are a lot of provisions on accountable government in the North Korean constitution, and every institution is accountable to another. And as David, you are pointing out, that might mean something that we quite don't get from the text of the constitution. It certainly doesn't mean democratic accountability, but maybe it's a way to refer to some kind, I don't know, of ideological consistency or something there. But here, the text provides much less clues as to what it means. As for rights, where I find it's one of the surprises from the North Korean constitution, I find it very explicit about its collectivist, non-individual conception of rights.
Yes, thank you. And the hope, of course, is that this webinar, this report will facilitate interaction from the North Korean legal community. So maybe you and I and everybody else will have a better opportunity to understand this internally at some point. Keith.
Yes, we have two final questions. I'll share them both at the same time. So David, Professor Zhang, one of our participants in the workshop, sent a question, which I would suggest would be somewhat controversial. His point is, from the political reality of North Korea, could it become a better country if its political system was changed to that of a monarchy? That's the first question. The second question, we'll go back to David Kinney. John Delury has a follow-up. John writes, David Kinney raises fascinating questions about the similarities and differences between the concept of the Irish people as articulated in the Constitution of the Republic of Ireland versus the Korean people. But I'm struck by the underlying unanimity in the ROK and DPRK on the definition of the Korean people as an ethnic group inhabiting north and south of the 38th parallel, and perhaps the diaspora as well. In this sense, the problems of Irish division and Korean division are fundamentally different, and Korean division easier to solve. And he has easier in italics. So David first, I suppose.
Sure. Okay, I know you're asking me the question about monarchy because I have taught about this and written about this. And as we advise reform in the rest of the world, I admit I'm a little unusual in that I have a sneaking affection for constitutional monarchy as a way to solve certain kinds of con-design problems. Now, the reason for that, though, is that constitutional monarchs really are subject to limits. Some of those are explicit in the text of the Constitution, and some of them have just grown up over the centuries. So there's an understanding of the role that the monarch is supposed to play. And I think often the nature of political emotions in a country are such that they need a monarch. And it's sometimes good to have a monarch because if you don't have a monarch, you're going to have a completely popular and domineering president. And so a monarch can take away a little bit of the threat of the presidency. So the short answer is, would North Korea be maybe a better political system if it were a monarchy? My answer to that is yes, actually it would, better than now. But there is also, of course, a follow-up question, which is there any realistic chance of that? And my answer to that is no, I don't see any realistic chance. And it's not just because the North Korean government is going to be resistant to changing in that way. It's also because constitutional monarchies work when they grow up over time with a whole set of implicit contracts between the monarch and the monarch's people. And there's a kind of familial connection that has to exist there. We know, of course, that in the North, the Kim family uses that kind of rhetoric all the time, but they're very much, I think, trying to construct it right now, whereas monarchy depends on it being pre-existing and sacralized by time.
Thank you. David, would you like to go ahead with the other question from John Delury?
Thank you so much, Keith, and thanks, John, for that excellent question. I think there's a level on which John is sort of self-evidently correct that the problem we face in Ireland is that there are two peoples, or to put it another way, that the broader category of Irish people, or the people of Ireland that might hold sway in some communities includes a group that emphatically does not want that identification, and the challenge of unification would be to create a popular identity that was sufficiently unified in terms of its culture, outlooks, values, experience to form a functioning polity. And in that way, I was sort of just interested in many ways in the broader themes that came out of this conference, that in looking at these two constitutions and the values and the core beliefs and the different approaches to law and government that were espoused in the two, it seemed to me that often we were mapping some commonalities and some differences in the legal cultures, then to some degree the political cultures of North and South Korea. And it's one of the things I found so incredibly valuable about this project and so interesting, was to get some insight into that. And it's something that I hope I can learn a lot more about. But I think that certainly the problem is different, but ultimately the problem is always on one level the same, trying to find enough commonality to build a common culture, if that's ever something that is to happen. And interestingly, both the Irish and the Korean constitutional orders provide for some sense that could happen someday. So in that, there's a similarity, I think.
Well, thank you. Thank you very much. As we conclude, before I provide some closing remarks, Professor Williams, anything you'd like to say?
Just again, thank you, Keith, for your confidence in us. And this was really, really interesting and just a wonderful venture, because we had, to be blunt, these 13 con design nerds, people who think all of this is very interesting, who gathered for hours at a time. And we felt comfortable in each other's company and comfortable talking about matters that sometimes are so charged, so fraught, that people just avoid them. And so I'm very grateful for your commitment to opening up this potential Pandora's box or this potential path to enlightenment, but we won't know which it is until we start.
Well, thanks, David. And as we've discussed before, this may very well be the beginning of more projects down the road, touching on similar themes. But I want to thank you. I'd like to thank Elizabeth Adams of your team and others with the CCD and the School of Law. I'd like to thank James Min, Esther M., Daniel Wirtz of NCNK. And we really appreciate all of the assistance that went into the workshop. We thank the panelists, some of whom are with us today, some could not be with us. But this was a project involving so very many people. So on behalf of NCNK, thank you very much, and we look forward to possible future collaboration. Have a good day.
Thank you.
you.